please the court? My name is Jean Henney, and I represent Mr. Vachon in this appeal. I would like to reserve 5 minutes for rebuttal. Okay. This is an appeal from from an order granting a new trial in an uninsured motorist case. Mr. Vachon argues that Travelers Insurance was not entitled to a new trial because they were not denied a fair trial. Mr. Vachon was rear-ended by an uninsured motorist in 2011, and he looked to his insurance carrier, Travelers, to pay for his expenses and damages as a result of the accident. The parties engaged in extensive pretrial litigation. They ended up having a 4-day trial. And after the trial, a verdict was reached in favor of Mr. Vachon. Travelers moved for a new trial, and the trial court granted it. The new trial was granted based on 2 comments that were made by Mr. Vachon's attorney right at the beginning of opening statements. And those 2 comments are, so what is this case about? We have a little bit of a flavor in the questioning of the jury panel. It's not your typical personal injury case. It's actually a breach of contract case. It's a case about keeping promises because that's what insurance policy is. Objection, Your Honor. Argumentative. Sustained. And within a little bit, short time after that, Mr. Vachon's attorney says, so when he was injured, the evidence will show he went to them, and I have these injuries. They're permanent. I have wage loss. I have medical expenses. I have pain and suffering, and the evidence will show that when he went to them to get reimbursed, well, why do you think we're here? Because they're not willing to do that. Motion for a new trial. New trial was denied.
Motion for mistrial.
Motion for mistrial. Sorry.
Yeah.
Yes, thank you.
That's an interesting ripple here. It occurs to me if the judge had granted that motion for mistrial right then and there, and said, you know what, this is in violation of the rule in limine. This is not, this is in violation of the law. This isn't a contract case. Yes, it's how it gets here, but really the law's clear. This is really supposed to be tried as a tort claim, and you've just basically inserted in there, this is about Travelers not keeping promises. Bad insurance company took the guy's premiums, didn't do what they were supposed to. If the judge had just granted the mistrial right there, would we really have an argument? Because really, it occurs to me that the reason why this is here is because we all ended up getting a peek at what the verdict was.
Yes, that
Yeah.
is exactly why we're here, yes. Well, the problem is uninsured motorist cases are hard to explain to the jury why Travelers is...
I agree, and in reading the voir dire, I think plaintiff's counsel hit it pitch perfect in voir dire. Basically said, hey, look, everybody, this is an insurance case. Travelers is the insurer, but really it's a tort case. I'm quoting, but really it's a tort case involving another driver. I mean, that was pitch perfect as to what was really happening here and what the law says these cases are supposed to be tried. But then in the opening salvo of the opening statement this is about not keeping promises by the insurance company. And actually, if you read the opening statement, it wasn't just at the very beginning. They circled back around at the end and mention again, hey, Travelers Insurance isn't paying this claim. So, I mean, to me, that looks more like a theme.
Well, what's interesting, that if you look at it, this was a 4-day trial, 1,000-page transcript. You have just these isolated oblique comments.
And it's interesting, Ms. Haney, because didn't the judge himself at the very beginning, and I quote, in the introduction said, quote, this is a contract case, but it also involves what is called a torts. I'll have the lawyers explain that. He said that this is at the very beginning, I guess right before voir dire, when he gives a little bit of the case itself.
Yeah, the seats aren't warm yet. The judge says, my name is this is a contract case.
And this is what he said. And he said that the lawyers will develop that later. And during voir dire, the questioning has all been, and everybody, I thought that the attorneys, both sides, restrained themselves from really, because usually for voir dire, people go overboard in terms of some of the claims that some of these potential jurors had, but just went in and asked about that. So I guess, which leads to my question, this one statement that was said at the beginning, it had nothing to do, because I sought the motion for a new trial, and I read the motion for a new trial, and when I read the motion for a new trial, I'm like, that is a far cry, and you have to read the whole transcript to get a flavor. And things about, what's the term that was used, this record is, that the attorneys improperly argued on claims handling practices. The only statement that I saw is this opening statement about that. So in my mind, I'm thinking, does that reach such a level of a 4-day trial where it's a fairly clean trial? Does that mean that the defense did not have a fair trial?
Well, I would say it's more than a fairly clean trial. After that, besides these isolated comments, it was almost a perfect trial. There's hardly any objections. The judge at the end says, congratulate, it's a pleasure trying the case with you. I appreciate your professionalism. There was nothing in the trial other than these statements. And you're right, the motion for limine was claims handling, premiums, bad faith, none of those things. So when you talked about a theme, what was Traveler's theme? Traveler's themes, the customer isn't always right.
And they mentioned that during en voir dire. That was the questioning of every juror, is the customer always right? So when you think about customer right, doesn't that play in with the other side saying, it's a contract, they didn't meet? I mean, it didn't even say that. All that it says here, and I quote, the problematic, it's a case about keeping promises. That's that one sentence.
And what is a contract? If you're explaining a contract to a jury, a layperson, it's a promise to pay.
Well, and then at the end of the opening statement, he says that Mr. Vachon doesn't want your sympathy, he wants the benefits of his policy.
And that's the contract.
Yeah. I mean, but it's,
But
he has now said, listen, I'm going to, at the beginning of it, I'm going to lay out these pieces of the puzzle, and I'm going to try to put this all together for you. Use the classic puzzle metaphor. And the puzzle that he put together was, insurance company has a contract, they're not paying the contract, this is a breach of contract case, he wants his benefits under the policy. From there, everything just kind of flows along that, but he's now framed this for the jury in a way that says this is about an insurance company not paying a policy.
And what does Traveler say? The customer isn't always right. We were right not to pay the policy. So after these statements are made in opening statements, Travelers,
but at this point, their motion for mistrial has been denied. They've got to deal with this some way, right?
Well, they've already dealt with it in the way that they dealt with it at voir dire. So the thing is...
Let me clarify that. The judge never denied the motion for mistrial. The judge just said, I'm holding it under advisement. So there's never been a definite ruling on the motion for mistrial. He gave a curative instruction at the beginning, and then later on he said, your objection is noted, but I thought the court said it's under advisement.
It's on record page 1542, and since we don't have paper transcripts anymore, I have it written down that he denied the motion for mistrial.
So he did, okay. What page?
I have it at record 1542.
Thank you.
And I would have to look at that. But yes, so in order to get a new trial, the comments that were made had to be improper, highly inflammatory, and prejudicial. And we would argue that, one, that they weren't improper. They didn't violate the motion in limine because the motion in limine dealt with claims handling practices. There was nothing about premiums, hold them accountable, hold them responsible, bad faith, those types of things.
I mean, yes, you're technically correct. They did not say Travelers is engaging in bad faith. They're not doing proper claims handling. But the plaintiff's attorney is saying, look, they're not paying the benefits of the policy. He just wants the benefits of the policy. I mean, what other conclusion is the jury supposed to draw other than that they're not doing what they're supposed to do?
Well, the conclusion that they draw is that they're an uninsured motorist case, that there is a policy that it
already been explained, already been touched on. Didn't need to go there at all.
Well, so there was a curative instruction given. So
which the defense did not want. I mean, they made that very clear, Judge. A curative instruction isn't going to fix this. Hey, do what you want to do, Judge, if you think that's going to fix the problem, but we don't think it is. I mean, they've made that clear and they preserved that issue.
Right, but the case law is that even highly inflammatory comments can be cured with a curative instruction. So what the judge did was say, look, these are the issues that we have here at trial. And the issues are, was there an injury, and what are the, his expenses and damages associated with that injury. And that's the way the 4 days of trial went. That's the way closing argument went. And
by the way, I agree with your assessment. It looks like a clean trial going from there forward. How do you deal, though, with our review of this kind of ruling where it's not just, there's almost this sort of super deference to if it's a motion, and I hate the heightened standard of abuse of discretion, whatever that means, but this notion that, look, if it's an order granting a new trial, and you've really got to show just a bad, not like bad faith, but just a real abuse of discretion above and beyond the garden variety kind, I guess.
Yeah, former Judge Altenburn has a big thing about, is there such a thing as abuse of discretion, higher abuse, whatever the abuse of discretion is, whatever it is, it's within a framework. So it's not the errant knight running around just making these decisions. And the framework is you get a new trial if you're denied a fair trial. Mm-hmm. What is a fair trial? A fair trial is one in which you don't have improper, highly prejudicial, highly inflammatory comments that affect the verdict. And that is what we don't have here. We have a couple of, if you have isolated and oblique statements in a 4-day trial, there's a corrective instruction given. It is an abuse of discretion to grant a new trial. The Tanner case is the closest I have.
And it's interesting, Ms. Hand, because you have to look also, in reading through this record, it appears that the judge was actually surprised with the pain and suffering award. And at least based on that, I think he was swayed into, well, pain and suffering, and I think the other side kept saying, but Judge, my client is likable, that's why they've awarded him. He did, there's evidence of that, and you seem to focus more on that award, because if you look at the verdict, both sides, the travelers got some great result in that verdict at the beginning. They didn't award a lot of stuff that that the trial lawyer below on the plaintiff side asked for, and it seems to be the only thing is this pain and suffering thing, and it goes back to the heart. You have to look at the whole transcript to make a determination. Did travelers, was the trial fair, or there's, based on that one statement, it totally vitiated the fairness of the trial?
Yeah, and when you look at the verdict, you're right. Mr. Vachon didn't get everything he asked for. And he got an amount for pain and suffering that he didn't ask for. He just left that open.
I think the argument was $40 a day, and he has 2,000 whatever days in his life, 27 point whatever years in life expectancy, and plus from the date of accident. I mean, that's what the number that was thrown out. And obviously the jury didn't award everything, but they gave him what they thought was appropriate.
And it was appropriate based on their own expert witnesses' testimony. So they have their, Dr. Shim is their forensic orthopedic that comes. And he looks at, he says, yes, Mr. Vachon was injured in that accident. He had a sprained neck and a sprained injury. He had pre-existing conditions. And then he was asked, could this accident have made pre-existing conditions that were asymptomatic, no pain, into a painful situation? And he said, yes, that's possible. And then you have Dr. Foley, who's their radiologist, who explains in great detail why that is. The jelly in the disc, protrusions, bulges, extrusions, they shift over time. You can have a minor accident where you have these pre-existing conditions, you have an asymptomatic person, and they become symptomatic. Dr. Shims asked, could that be permanent? And he says, yes, that could be considered permanent if that pain existed for more than 6 months. So what they denied was, they bought all that. Then they get to the jury instruction about pain and suffering. Can you separate out what happened from pre-existing conditions to, after the accident? And if you can't separate it out, then you award based on that. So they denied the surgeries that Mr. Vachon's expert said were necessary from the accident. So they gave him almost $300,000 less than he asked for. But the verdict was a jury that sat and carefully listened to the cross-examinations of Mr. Vachon's experts and listened to the testimony of their
I want to go back to
experts.
this notion of isolated comments. I'm not sure I agree with that characterization. When it's brought up once, there's an objection, they go back to it and expound upon it, and then at the end of opening statement, they go back yet again to say, hey, they don't want your sympathy, they just want travelers to pay what they owe because he's paid his premiums, words to that effect. I mean, to me, that's a theme. And the issue here that I've got with that as making that a theme in an opening statement is that if this had been just a direct, typical, more typical, kind of car crash case where it was Mr. Vachon versus Mr. Hildenbrand, and if plaintiff's counsel said something along the line of, hey, don't worry about Mr. Hildenbrand, he's got traveler's insurance and they're the ones that are going to be, there's no question that isolated statement would get you booted out on a mistrial, even though it's isolated, even though you could get a curative instruction. Is this really that different when the law says we're supposed to be treating these more like a tort claim, but in opening statement we keep talking about the fact that it's an insurance company not doing what they're supposed to do?
Right, because these comments didn't tell the jury anything the jury didn't already know. They knew all of that, but
Well, that would
when
be
they
true,
sat
but
down-
that would be true in the isolated comment about, hey, they've got an insurance company. I mean, yeah, all the jurors know, yeah, everybody has insurance, they're supposed to, everybody's supposed to have insurance, and that really it's the insurance company that's paying it. And yet still, that has become kind of just a red line you don't, it's a guardrail you don't touch. And I'm wondering, why isn't this like that?
Well, I would argue it's not like that because my first comment is that the judge told the jury before they sat down, this is a contract case, and then both sides did during voir dire, this is a
That's
contract.
half correct. He said it's a contract case. It's also,
So
it is
personal
a
injury
tort
case.
case,
Yes,
and that's,
yes,
and that is what we were going to focus on. And indeed,
Right.
that was what the trial did focus on, was this claim, and we had the experts go back and forth about, all of his prior injuries and how that affected him, his ability to serve in the police.
But the insurance isn't, aha, we've introduced something, and that was probably a motion in limine, an order in limine that specifically said you can't, talk about insurance. And then that was brought up. In this case, it said you can't talk about claims handling practices, premiums, length of time that you were, uninsured. And if you look at the cases where there are new trials in these cases, this isn't even close. You have cumulative statements, you have victimization of the insurance company, you have, I paid these premiums all these years, is this what it means to be in good hands? Looks like the claims department never met the sales department, the customer service department. You have sort of this badgering the insurance company.
So we write this up as a reversal. We include all of the comments that get made in this opening statement, and that now becomes the new floor of a gross abuse of discretion to grant a new trial.
And I think that you can do that because the focus, when you look at the entire trial, the 4 days of trial, these comments did not refocus the jury's, it did not prejudice. They were not improper, highly inflammatory, and prejudicial that denied travelers a fair trial.
Well, they're improper insofar as, the law says that these claims are supposed to be tried as if they are tort claims. And instead we have, an opening statement saying, no, this is about getting the benefits of a policy. I don't think you can make the argument that these were perfectly fair, proper arguments given the issues that were supposed to be litigated. I think there's a level of impropriety. I think what your better argument is that this is not the kind of impropriety that ought to rise to the level of a new trial.
That denies a person a fair trial with a curative instruction.
Well, that's where it's missing in this exchange, is that in this case, you have a curative instruction given by the court, telling the jury, here's what it is. And then after that, that's it. Nothing was mentioned, nothing was brought up, no other issues with that. So you have a statement that immediately was given a curative instruction. Then you go through a 4-day detailed trial, extensive testimony, extensive that, and superimpose that with the questioning in voir dire by the insurance attorney saying about the customers is not always right. I think you have to look at the whole totality thing. So it boils down to, did travelers get a fair trial under this record? This is, I think, what it distilled.
Right, yeah, and I would agree with that. And that would be our argument, is that you only get a new trial if you were denied a fair trial. And under even any abuse of discretion that you use, when you look at this case in the totality of the entire trial and how cleanly it was tried, that Travelers was not denied a fair trial. And that the judge, when he made his decision, he was looking at the verdict, and that the verdict is actually very consistent with the evidence that it's spot on with the evidence that Travelers presented. I reserve the rest of my time for it.
Thank you. Good morning. May it please the court. Jack Ryder and Jordan Cautious on behalf of Travelers. Your Honors, let me start by saying that, to be clear, there was in fact a motion in limine. The motion in limine was specifically granted, the record at 767. That motion precluded references to general bad faith or insurance claim practices handling. That issue came up again right before trial, and there was a conversation, a discussion before trial, and this entire issue was renewed again, and the concern was made very clear.
But looking at that, it was dealing specifically with bad faith, and everybody knew we're not going to talk about bad faith. Claims handling, we're not going to talk about that. In this case, you have to look at the statement that was made. I mean, really, we're talking about one statement that was made by the attorney. Does that vitiate a 4-day jury trial and add to the fact that a curative instruction was given appropriately and promptly? That's where I'm having a problem with.
I understand,
This is
Your
not
Honor.
dealing with, and look at the voir dire with the attorney below. Goodness gracious, everything, the customer's not always right. The customer's, and then he focused on the theme of, okay, dealing with that. So that's where I'm struggling with in this case.
Of course, Your Honor, I'll address that
I
directly.
think I telegraphed that based on
A
my
little bit,
questions
Your
to
Honor,
the
a little
opposing
bit.
counsel.
No, I anticipated that, Your Honor, and I'm fortunately I'm well prepared to address your concerns. First of all, this is not one comment. I want to make this very clear. This was, in fact, as Judge Lucas pointed out, this was a theme.
Okay,
Why is it a
then
theme?
tell
I'm
me.
going to highlight all
Point
the
me.
comments. Of course, Your Honor. Opening statement, and I think this is important. I'm going to put it in context. It is very common during voir dire to explore biases. Comments are made during voir dire. There's references to, do people work for insurance companies? Anyone in their family work for a claim? That's not uncommon.
But that's okay, and there's no problem with that, correct?
That's correct.
All right.
But that's not what happened here. This is the opening statements. These are the themes. What's this case about? This is plaintiff's counsel. This is at the record at 1093, 1094. So what's this case about? It's not your typical personal injury case. That's how he starts. That's incorrect right there, Your Honor. This is a personal injury case. Once those parties
He
went...
said, but wait, but he said not a typical case because you're dealing with the defendant who is an insurance company.
Your Honor, I respectfully submit that that starts off the theme, and then it continues, because this is how counsel built on this theme. What's this case about? It's not your typical personal injury case. It's actually a breach of contract case. It's a case about keeping promises, because that's what an insurance policy is. That's not one comment, Your Honor. That's multiple, and it continues. He continues, if I may. In that same, and there's no issue about the preservation of the objection made. And then he says, that's all part of the contract that they have with Darryl. So then when he was injured, the evidence will show, he went to them, said, I have these injuries, they're permanent. I have wage loss, I have medical expenses, I have pain and suffering. And the evidence will show that when he went to them to get reimbursed, well, why do you think we're here? Because they're not willing to do that. Why are we here, jurors? Why are you here? Why do you have to sit here and listen to the evidence? Because travelers won't step up to the plate. They won't do what they're supposed to. They won't keep their promises, because that's what an insurance policy is. And then at the very end, as Judge Lucas pointed out, it comes full circle to the idea he just wants his benefits paid. The case is not about that. And there is a legion of cases, Your Honor, which I can go through.
No, and believe me, I'm familiar with all of that.
Of course.
My question is that statement, when you said at the very end with the benefit, what page is that? Because I don't think there was any objection to that part of that when he made that statement, correct?
Your Honor, the judge, I believe you're correct, but the judge had
All
already
right.
overruled the objection. And I did want to point out one clarification. At the record at 1882 and 1883, there was a renewed motion for mistrial that was reserved. I just wanted to make sure I made that
I
point.
thought the judge, it was my error. I thought the judge reserved at the beginning, but you're correct. The judge denied the mistrial, but then it was renewed, and then he held it under advisement.
Yes, Your Honor.
So I guess I'm concerned with the characterization that we made, that the opening statement was replete with this theme. All I see is this one statement that he made, and as a result of that one statement, a curative instruction, you did file a motion it was moved for a motion for mistrial. The court immediately granted a curative instruction, and then it went on its way and on its way. And then we're dealing with also the very, where people don't even focus on that, the jury instruction that say what the lawyer says is not evidence. Look at the facts, look at what's presented, and do you vitiate a 4-day trial because of that one statement?
Your Honor, the answer, respectfully, is to be left to the discretion of the trial court. And there's a few issues here that I think are significant. Your Honor is characterizing it as a single statement, and I respectfully submit that this was a theme. And I'm not, this isn't about whether it was intentional or by oversight or because it was confusion. You'll recall from the record is that when Travelers' counsel at trial said, Judge, a curative instruction is not going to cure this. And then he even said, and if you are going to give an instruction, tell the jurors that it's not a contract. It's not about that. Judge, at that time, the trial judge said, well, I'm not going to tell them it's not a breach of contract case because that's what it is. So there was confusion.
No. But the judge later on, I think the lawyer wanted to say, make sure you say they also have to prove causation and all that, and the court did that.
But the judge would not give the instruction that abused the jurors of this impression, this misimpression, that as they examine the case from this lens, the lens of how they view the evidence as it was presented, that they view it through this notion of, let's not forget why we're here, because they won't step up to the plate, they won't pay. And why? Because they're not keeping their promises. And it's not a typical personal injury case, but those are all different. Those are not, I would respectfully submit, that's not one comment, Your Honor. And I do believe it's critical to reiterate for the court's consideration, as the court is well aware, that when we look at the vantage point of the trial court's position, that the extraordinary level of deference, Your Honor, Judge Lucas called it super deference, in Thigpen versus United Parcel Service, the 4th District said, a stronger showing has usually been required to reverse an order allowing a new trial than to reverse an order denying one. This judge...
And I have no dispute with that, and you're absolutely correct. But then, fast forward to the motion for new trial. Don't you agree that, we have the transcript right here. Judge Barbas was so focused and so concerned about the pain and suffering amount. He was just, that's, I think, what drove him to grant the motion for new trial.
I respectfully disagree, Your Honor, and I'll tell you why. I think that was part of it. But if you'll look at the transcript from the hearing on the motion for new trial, which I know Your Honor has, of course, I don't have the citations in front of me, but there was a hearing on the motion, and Judge Barbas, when we had the hearing, he went back and he said to counsel, he said, I'm looking back at these comments, and they really are improper. There's just no way you can justify this. And he said, as I look at these comments, they really were improper. And I think, and that's one of the benefits, and when you have a trial judge, and that's why the discretionary standard is so critical, the judge, he presided over those days of trial. He presided there. He listened to the evidence. He observed it. He watched the evidence. He watched the way the jurors reacted.
Here's I think, where
Yes,
you
Your Honor.
kind of have two themes or two ideas that kind of bump into each other on these motions for new trial. The one is that, I think this is to Judge Guzam's point is that, look, we're only supposed to really be concerned when comments, improper comments, vitiate the entire trial, vitiate the fairness of the trial such that, we can say, yeah, you need to give a new trial. The problem is that from the trial judge's perspective, that's a hard call to make, and trial judges aren't supposed to step in as seventh jurors. They're not supposed to undo the sanctity of the verdict. The problem is that in order to make that judgment call, to some degree, the trial judge is going to rely upon looking at the verdict.
That is true, Your Honor.
I mean, there's no getting around that.
It does, that's true. It helps guide, but I think what's important here is that the judge did reserve on the second time it's raised. So he felt that there was an impropriety. He sustained the objection. He reserved on the motion. And then when he looked back on it and he evaluated it, and he took it under advisement, which he said was an unusual step for him. He really wanted to give this focus, which highlights the incredible effort he made in order to evaluate and to exercise his discretion carefully. But I also want to highlight the Special versus West Boca standard, because I believe that is applicable here, because it goes to the issue of whether or not, when Judge Barbas denied the requested curative instruction, at the end of the day, the question is there a reason, and the comments, and I'm going to point out, there's a case that came out today while we were sitting here in the courtroom from the 3rd District, which I obviously couldn't cite as supplemental authority, but it literally came out while we were here, and I'll just highlight it for the court, just because it's...
In fairness.
I know, Your Honor. It literally came out while we're here. I won't even mention it, but I'll file a supplemental authority. But the bottom line is there's so much authority already in place throughout the state, including this court, that talks about the fact that if there is a reasonable possibility that the error or the improper commentary coupled with the error affected the outcome, it is the burden on the moving party. It is the burden on the plaintiff, the appellant, to show that there's no reasonable possibility that the error impacted it. And
I want to make sure I understand how special comes into play here. I think what your argument is that when considering a motion for a new trial, there's some law that says the trial court is supposed to almost assume the role of a court of review in looking back over its own shoulder. And since it's assuming that role, therefore you utilize the special standard that a real court of review would otherwise utilize when reviewing, the effect of the benefit of the error. Has any court ever said that actually a trial court is supposed to utilize that? Because it kind of struck me as a little bit of a curveball reading through this.
I have seen courts use that analysis. I've seen circuit courts use that analysis, like published circuit opinions. I have seen appellate decisions that talk about the application of that standard, and I do think it's appropriate and not improper for a trial court to examine whether or not an error that judge committed, whether or not there's a reasonable possibility in evaluating the impact of the error, that is there a reasonable possibility it affected the outcome. And I won't cite the case that came out today, but when I file a supplemental authority, you'll see that it supports that logic. I also I think it's important to point out, this court and others have found that comments just like this are improper and have reversed orders denying motions for new trial for similar comments. And when we talk about, for example, Carvajal versus Penland, just like this case, there was a motion in limine that coverage was not an issue in an uninsured motorist case. There was a comment by the plaintiff. There were I believe two, and maybe more than two comments, because there it was a witness, it was the plaintiff and the lawyer. But the court talked about the fact that these comments are improper, inflammatory, and mandate new trial. And here's the important language from this court. This court decided in State Farm, Carvajal versus Penland, the court concludes that, quote, independently and cumulatively, the motorist's testimony and her attorney's closing argument warranted granting a new trial, independently and cumulatively.
And that's true, Mr. But if you look at the facts of that case too, and if you look at what was said and the impassioned statement in closing argument plus that testimony, that is a correct decision under the facts of that case. We have to look at the facts of this case.
And Your Honor, I would respectfully suggest that if this is a matter of degree, and the question is, was it enough? Were these multiple comments in opening statement, which Judge Lucas characterized as a theme?
When you say multiple, all I see, there's one, and then it's a long one, but there's like a couple of comments, but you say, the way that you characterize it, you think, oh my God, it's replete with a lot of that.
Your Honor, I talk about, and I've highlighted this, I think I said this at the trial court level when I was arguing the argument on the motion for new trial. Jurors, I believe there's principles of primacy and recency. And I think when the opening statement is, what's this case about? It's not your typical personal injury case. It's a case about keeping promises. It's when you start off that way.
The main reason I'm smiling, because there's argument be made the other way. There's people say,
Of
oh
course.
no, it's whatever, the last thing that you hear,
And
that's what you go. So that for me
Primacy and
is
recency.
I know, that's not, let's look more as, I guess right now is what was said, yeah, it was a true statement that perhaps should not have been said, but then there was an immediate curative instruction given. And
You're-
then, was there anything else, Mr. Ryder, and the rest of the trial, in closing arguments, anything else that was said or done to be able to focus this theme again?
Your Honor, the theme comes through. I don't recall a specific statement, but the theme comes through. And there is some reference at the end to the verdict, because the theme comes through, because what you have is you have a situation where you have a plaintiff who was well-liked, and you have unfortunately, this entity, the insurance company, that's not well-liked. Why is it not well-liked? Because it wasn't keeping its promises to its insured. The verdict does speak volumes about this, and Judge Barbas, when he evaluated it in his discretion, after examining the totality of the evidence and listening to the issues and going back over it in detail, he said this doesn't make sense. Not only were the comments completely improper, that's what the judge found. And I don't think there's any serious dispute to suggest that they were proper. I believe that they were absolutely improper. Once Judge Barbas looked back upon that, and he said, I see this, the jury clearly rejected these medical damages awards. They rejected them. They awarded minuscule percentages of what was asked for, and yet they came back with this high verdict. During post-trial arguments, counsel, said, well, that's because they liked Mr. Vachon. Well, he may have been a very likable person, but the law doesn't provide, do we give the verdict to the person we like versus the company we don't like? And that's why it creates a theme that unfortunately does carry through. Because I hate to talk about the counsel because I don't want to make it about the attorney. I mean, these comments get made, and unfortunately it got made, and Mr. Vachon will have his day in court. He will have an opportunity to go back and have a retrial and to present the evidence again, and he's not prejudiced by that. But Travelers was prejudiced. Travelers was prejudiced because if this court were to reverse and reinstate a verdict, that means Travelers has been saddled with a verdict that we respectfully believe, and more importantly, Judge Barbas believed in the exercise of his discretion, was the result of these comments.
And the bottom line is here, and I think the big hurdle that your opponent faces, it is an abuse of discretion standard.
And even the higher standard, Your Honor.
And it's a high because it's a granting of a motion for retrial. That's the hurdle that's facing the other side.
And I would respectfully submit that they have not overcome that hurdle here, Your Honor. And Mr. Vachon will have his day in court because the new trial will go forward. In fact, if they hadn't appealed, they would have probably had the trial by now. So, I only say that because it's not as if he's going to be deprived the opportunity to present his case.
No, but again, 4-day trial, extensive testimony, extensive this. When you say he's not been prejudiced, it has been prejudiced. That's a 4-day, and there's a lot of things that are involved. So I would question that.
I understand, of course, Your Honor. I am probably close to or out of time. I don't know.
Yes, you've got about 2 minutes.
Okay, well, I did want to just, Allstate versus, there are so many cases. I mean, I could go through them all, but there's Allstate versus Murata, Auto Owners Insurance versus Dewberry, where the court talked about the fact that it's improper to bring references to any insurance issues in these uninsured motorist cases. State Farm versus Revuelta out of the 3rd District. The counsel implored the jury to call the carrier to account for those responsibilities they undertook under the policy. And the court held that the contention that State Farm was refusing to own up to its responsibility improperly shifted the focus of the case and improperly suggested that they should be punished for contesting damages at trial. That's exactly what happened here. And I think it's important, Judge, that it's not just about the improper reference to the claims handling practices. And that's what it is when one says they're not keeping their promises, they're not doing the right thing. That's a violation of the order in limine, and it's a violation of established law. But there's something else here, and we put this throughout our brief, and I don't think it's really been addressed, and that is Travelers was also being blamed for defending itself. And why? Because it's that statement of, why are we here? Because they're not willing to pay. So that's two different themes that are being invoked by the improper opening statements. One is, an insurance company has a duty to pay its policy and live up to its obligations, and they're not doing it. And two, they should be punished, he didn't use those words, but saying, why are we here? Because they're not doing what they're supposed to do. And that is criticizing the company for choosing to defend itself at trial. And that is an entirely, and Judge Barbas was all on this too. Judge Barbas, in his ruling, in his order, and in his comments, made a point of that. And if we look at some of these cases, like I just mentioned, State Farm versus Revuelta, State Farm versus Gold. And I do want to point this out, because I intended to say,
Wrap up, sir.
and this is the wrap-up, thank you. State Farm versus Gold, the court rejected the notion that a few fleeting comments were not enough, because it could not be said that there wasn't a substantial part of, and the court said, although it is true that the comments cannot be said to make up a substantial part of the total statements, their effect was far from inconsequential. It's exactly what we have here. And then again, that it is really the trial judge whose role it was to evaluate this, and we respectfully request that this court affirm. Thank you. Thank you.
Just a couple quick comments. On the order granting the new trial, the judge granted the new trial based on the two comments that I read initially. So that is what this court makes its decision on in terms of whether the trial judge abused his discretion in granting a new trial based on those comments. And in terms of the abuse of discretion standard, the discretion is within a framework of you get a new trial if you're denied a fair trial. An unfair trial looks like the cases that were cited by Travelers in their briefs. In those cases, there's calls to hold the insurance company accountable, comments on the premiums, comments about making them responsible, comments that the client's a victim, that the defense company is acting in bad faith, manufacturing a defense, failing to accept responsibility. Those are cumulative comments, they're egregious comments, they're inflammatory, they were intended to prejudice. And in this case, you can't look at this verdict and say that Travelers was prejudiced, because the verdict does represent what the evidence was that their experts presented and what the jury instruction was regarding separating the pain out in terms of pre-existing conditions versus, after the injury. So if you have, it's undisputed that, Mr. Hildenbrand was solely responsible for the accident. It's undisputed that he was injured by the accident. It's undisputed that his pre-existing conditions could have been aggravated by the accident. And it's undisputed that he had significant loss of enjoyment of life after the accident than he had before, including having to give up his position at Lakeland Police Department, unable to passing firing exams because he could no longer lift his neck without a lot of pain.
Well, given all that, you sort of have to wonder why, especially in light of the motion in limine, counsel would even go there.
Well, the motion, so if you look at the motion in limine and the argument that was made, he said he had to explain that this is a contract case. And the judge says, and Traveler says, no, we're not talking about a contract. And he says, well, I have to say why I'm here and talk about premiums. And the judge says, no, you can't talk about premiums. And so, the judge sort of gave him the red light or the green light to go ahead and say, this is a contract case. I'm not saying it's not a contract case. I'm not telling the jury it's not a contract case, because this is. It's a hybrid case. And so he didn't. So he He is within the motion in limine and the orders in limine. Nothing about premiums, nothing about bad faith, nothing about victimization. He's telling them what they already know. And so we would argue that there was nothing inflammatory that prejudiced or denied travelers a fair trial.
Okay, thank you. Thank you both.